The year was 1870. The British Empire, vast and powerful, faced a growing unease in India. Nationalism was on the rise. Voices of dissent, once whispers, were growing louder. The British, always wary of threats to their rule, felt the need to tighten their grip. Their answer was Section 124A of the Indian Penal Code, the Sedition Law. This law, with its origins in 18th century England, was a tool designed to quell dissent. It criminalized any attempt to excite disaffection towards the government. Words spoken or written could now be deemed seditious. The colonial authorities had found a potent weapon to silence their critics. The introduction of the Sedition Law marked a turning point. It signaled the colonial government's increasing anxiety and its willingness to use the law to maintain control. This law, born of empire, would cast a long shadow on India's journey towards freedom. The British Raj, often presented as a period of stability and order, was in reality a time of immense social and political upheaval. The Indian people, subjected to economic exploitation and political disenfranchisement, were growing increasingly restless. The Sedition Law became a convenient tool to silence any opposition. Nationalists, reformers, and even moderate voices advocating for greater autonomy found themselves targeted. Bal Gangadhar Tilak, a prominent figure in the Indian independence movement, was one such victim. Tried and convicted twice under this law, Tilak's case exemplified the British government's readiness to use sedition to suppress dissent. The Sedition Law's broad and vague language allowed for its arbitrary application. Merely criticizing the government or its policies could be construed as an attempt to incite disaffection. Fear and self-censorship became the norm, as Indians were forced to weigh their words carefully, lest they be branded as seditious. 1947. India, finally free from colonial rule, embarked on its journey as a democratic republic. The Constitution, a beacon of hope and progress, enshrined fundamental rights, including the right to freedom of speech and expression. However, the legacy of the colonial era lingered. The Sedition Law, despite its inherent conflict with the principles of a free society, was retained in the Indian Penal Code. This decision was met with criticism even then. Many argued that this relic of the Raj had no place in a democratic India. However, the government, grappling with the challenges of a newly independent nation, argued for its retention to maintain law and order. The debate, though, was far from over. The retention of the Sedition Law presented a paradox. How could a nation that had fought for its freedom justify curtailing the very freedoms it had so dearly won? This question would continue to resonate in the decades that followed. In 1962, the Supreme Court of India delivered a landmark judgment in the case of Kedarnath Singh versus State of Bihar. This case, which revolved around the interpretation of the Sedition Law, would have far-reaching consequences. The court, while upholding the constitutionality of the law, attempted to narrow its scope. The court emphasized that mere criticism of the government could not be considered seditious. It drew a distinction between disaffection and disapprobation. While disapprobation or disapproval of the government was permissible, any attempt to incite violence or public disorder could be deemed seditious. The Kedarnath Singh judgment was hailed as a victory for free speech advocates. It provided some much-needed clarity on the interpretation of the Sedition Law. However, the law itself, with its potential for misuse, remained a cause for concern. Section 5. A chilling effect: sedition and the stifling of dissent. Despite the Supreme Court's attempts to narrow its scope, the Sedition Law continued to be used to stifle dissent and criticism. The law's vague wording and the subjective interpretation of terms like disaffection left it open to misuse by those in power. Journalists, activists, students, and artists found themselves facing sedition charges for expressing views deemed critical of the government or its policies. The threat of arrest and lengthy legal battles created a chilling effect on free speech. People became hesitant to voice their opinions freely, fearing repercussions. The use of the Sedition Law to target dissent raised serious concerns about the state of democracy in India. It highlighted the urgent need for a more nuanced and balanced approach to free speech, one that respected the right to dissent while addressing legitimate concerns about national security. Section 6. The fault line, free speech versus national security. The debate on India's sedition law centers on free speech versus national security. Free speech is vital for democracy, holding the government accountable, yet the government must maintain law and order, protecting citizens. The challenge is balancing these interests. National security shouldn't suppress legitimate dissent. Criticizing the government is fundamental to democracy. The sedition law's broad language favors national security too much. It silences dissent, creating fear and self-censorship. Section 7. Drawing the line, the need for narrow interpretation. The Kedar Nath Singh judgment did not completely address the problems inherent in the sedition law. The law's vague language allows for subjective interpretation and misuse. There is a need for judicial scrutiny and legislative reform to prevent misuse. Narrowing the definition of sedition to exclude non-violent speech is crucial. This would require a higher threshold of proof, protecting dissenting voices. Section 8. Global comparisons, sedition laws around the world. The debate surrounding sedition laws is not unique to India. Many countries around the world grapple with the challenge of balancing free speech with national security. However, India's continued reliance on a colonial-era law, despite its democratic credentials, has drawn criticism from international human rights organizations. The United Kingdom, from where India inherited the sedition law, abolished its own sedition law in 2009, recognizing it as incompatible with a free and democratic society. Other democracies, such as the United States, have strict First Amendment protections that limit the government's ability to restrict free speech, even in the name of national security. Comparing India's sedition law with those of other democracies highlights the need for reform. It underscores the importance of aligning India's legal framework with its commitment to democratic values and international human rights standards. Section 9, Safeguarding Democracy, Protecting Free Speech in India. The debate surrounding the sedition law in India is not merely a legal debate, it is a debate about the very soul of Indian democracy. It is about the kind of society India aspires to be, a society where dissent is tolerated, where criticism is welcomed, and where the free exchange of ideas is cherished. The right to free speech is not an absolute right, it comes with responsibilities. However, any restrictions on this right must be carefully considered, narrowly tailored, and subject to judicial scrutiny. The sedition law as it stands fails to meet these criteria. The time has come for India to move beyond its colonial legacy and embrace a more nuanced and balanced approach to free speech. Repealing or significantly reforming the sedition law would be a powerful symbol of India's commitment to democratic values and its recognition of the vital role free speech plays in a thriving democracy.